This screencast is to cover the 14th Amendment court cases, but here are some First Amendment cases we've looked at. So go ahead and pause it for a minute if you want, and you can see if you can remember what these cases are significant for. And here, 8, 9, and 14 cases we've covered so far in class all the way down to Planned Parenthood versus Casey. So this screencast will talk about Plessy, Brown, and then Bakke. So just keep in mind that the 14th Amendment has a few components. One, it means if you're born here, you're a citizen, but significantly for this unit, it has a due process clause, which is what the courts have used for selective incorporation, making the states follow the Bill of Rights. And there's an equal protection clause, which basically counts as our civil rights as we know it today, saying that all people must be treated equally under both federal and state law. So I want to start with this image, and I want you to take a second and pause it and just think through what's going on here. What do you notice? What do you see? What would it be like if you could zoom out of this image and see what was happening in real time? What's going through this young girl's head? Okay, now that you're back, we're going to jump forward and talk about that painting. It's painted after a girl named Ruby Bridges, who was an elementary student that was one of the first students that, or was the first student to ever go to an all-white school in New Orleans. And it was 10 years after the Brown versus Board decision that we're going to talk about right now. So here she is being escorted to and from school with U.S. Marshals helping her to make sure that the school gets integrated. And like I said, it's 10 years after this court case. So it took a long time for this court case to actually go into effect. And we'll talk about it in just a moment. But we're going to go back first to a court case that set the original precedent when it came to race and division based on race. It's called Plessy versus Ferguson. So this is a picture of a gentleman named Homer Plessy. And according to laws and legal codes during the 1890s, Homer Plessy counted as a black man. Even though his skin was very light, he was Creole. And one of the things he wanted to do to make a point is to ride on an all-white train car. And he was arrested and sued, and it went all the way to the Supreme Court. The question was it constitutional to have separate train cars? And the Supreme Court looked at the 14th Amendment Equal Protection Clause, and they determined that separate is okay as long as it is equal. So you get this established precedent of separate but equal is okay. So Plessy loses, and it reaffirms the Jim Crow era type laws that start to exist in the 1900s, where you have separate drinking fountains, separate school systems, and clearly, as we could see from the pictures, they weren't even close to being equal. So protests occur. There's a lot of racial tension around all races and ethnicities. And like we said earlier, there are separate schools that were clearly not equal in terms of resources or the quality of education that kids would get. So this leads us to 1954 in Kansas, when there were only 4 public schools for black students. And there were protests over whether or not there should be integration and desegregation between schools. And oftentimes, even when there was still tension around that. But one gentleman, Oliver Brown, lived in Kansas and wanted to send his daughter to the closest school, which was a white school. So he sued and said that Kansas's policy of having separate schools for black and white students violated his 14th Amendment Equal Protection Clause. So he sues. Just as a little recap up here, if you guys want to pause it and take a look at these things. But his argument, again, is the 14th Amendment is violated. And Kansas's argument is that Plessy versus Ferguson has already decided this, so there shouldn't be any issues. But, as most of you know, Brown wins, and the court overturns Plessy versus Ferguson. So we're looking at this being a judicially active decision, right? They're going against past precedent. They say legal separation based on race is unconstitutional. So this applies to public forums, and then ultimately today applies to most private forums as well. So Brown versus Board of Education is hugely significant in our nation's history, because I know it narrowly applies to schools during the case, but it also has been expanded, that idea, to apply to all places. Now, one of the reasons that the court started to rule this way is because they have created what we call classifications. So I'm going to make this first row available. This is a chart from your book. And the first kind of class that citizens fall under is called a suspect class. And it says that if laws treat people differently based on their race or other things like ethnicity or religion in some cases, then the court applies strict scrutiny, and there must be a compelling state interest to ensure that these laws are fair. So if you look at an example of when this was upheld, there's a court case called Korematsu versus the United States, which was when Japanese Americans were put in internment camps, and the Supreme Court actually upheld that treating of Japanese Americans as different, even though they were a suspect class, because there was a compelling state interest in national security. But most of the time, like in Brown versus Board of Education, if you can see right here, there's a pretty high standard for the government to prove there's a reason to hold people in different expectations if it's based on race, ethnicity, and religion. So just to explore this chart a little further, even though it doesn't fit with Brown versus Board, quasi-suspect class requires less of a standard of review to ensure that laws can treat people separately or differently. But so like gender would be an example. At this point in our court's ruling, sexual orientation would probably be a good example of what would fall in here, where there have to be very good reasons and it has to be an important state purpose, but not maybe a compelling state purpose. If you want to read these other two columns, you can look at some examples of cases. And then the lowest class of citizens, in order to determine if they could be treated differently, is called non-suspect, where things like age, wealth, and this, according to this chart, sexual orientation, although I would argue that that's changed since this book was written. Those are reasons why it might be more likely to treat people differently, and there's only needs to be a minimum standard in order to, and a rational basis in order to treat people differently. So that's kind of the classification piece. This isn't a huge deal for the AP test, but understanding suspect class and strict scrutiny and compelling state interest, those are all words that you're going to want to know. So some other civil rights topics that we didn't get to that fit with the 14th Amendment. After Brown versus Board in the 1960s, we've already talked about this, but in 64 there's the Civil Rights Act that's passed. And if you guys want to read more about this, you can pause. But basically what the Civil Rights Act does is it bans discrimination in any place that deals with interstate commerce, public or private. It helped desegregate schools more thoroughly and created this thing at the bottom known as the Civil Rights Commission, which basically allows people to file grievances to say that they've been discriminated against, and they go out and they try and attempt to right those wrongs. Just after the Civil Rights Act is the Voting Rights Act, right, which is looking at discrimination against voting. This is also right after the 24th Amendment is passed, which bans poll taxes. So this creates a federal supervision over voting, especially in these historically racist counties. This is the Section 5 that was overturned a year ago by the Supreme Court. But this idea of the Voting Rights Act protecting the right of minorities to vote. Another one that you're going to hear about is called Title IX. And here you see an image of a senator that authored Title IX. And he's running with some track girls at Purdue University. And the reason this image represents Title IX is because Title IX says that any institution that receives federal funding cannot discriminate against girls and women and must provide equal opportunities. So this is most commonly looked at in terms of high schools and colleges and providing athletic opportunities for women. So it's not the only case where it's utilized, but this is probably the most prolific and commonly referenced. So in this picture, you see that the law would state there has to be a girls' track team if there's a boys' track team. There has to be opportunities for softball if there's opportunities for baseball. There have to be winter sports for girls, like basketball or fall sports like volleyball if they're going to be sports for boys. So this is the significance of Title IX. It's greatly increased the opportunities for girls and women to participate, not only in sports, but in other things as well. One other 14th Amendment issue is around affirmative action, which is actively using race to help minorities that have traditionally been discriminated against achieve certain positions, either in universities and getting admitted to college or receiving certain jobs that traditionally wouldn't be open to them. So supporters of affirmative action say this is good, that we need to provide a stepping stool for minorities have been discriminated against, and opponents say that it is actually practicing kind of reverse racism where white people are discriminated against for the sake of race. So one case where that came up the first time in the Supreme Court is called University of California versus Bakke, is in the late 70s. And a little information, Alan Bakke, the gentleman in the top right, was denied twice admission into the medical school at UC Davis, which is a pretty prominent school and difficult to get into. And the school policy at that time was that there were 16 out of 100 places were reserved for high-quality minorities, so they could promote diversity and practice affirmative action. So Bakke sues and says that even though in both of his attempts he was higher qualified than all 16 of the minority students, he was still denied, and he sues and says that violated his 14th Amendment Equal Protection Clause. So this is an instance where you have a white person using this clause in the majority saying, I'm being discriminated against. And Bakke actually wins 5-4. So he must be admitted, and the reason the court says that is the case is because schools can use race as a factor in making decisions, but it cannot be a primary case like in this. And later the court ruled actually that you can't have quotas like this either, where there's a set number of minorities are going to be admitted. It can be used as a factor, like I said, but not a primary factor, and quotas are not okay. One additional group of people that have been protected by the 14th Amendment but would be a non-suspect class are people with disabilities. So in 1990, the government passed the Americans with Disabilities Act, the ADA, which basically ensures that all public and private businesses have to provide accommodations. All businesses provide accommodations and hiring practices as well, and schools that give opportunity to people with disabilities. This would be the law that requires businesses to have ramps or that are handicap accessible. It would require schools to provide an equal education for students with disabilities and without them. And this has been a significant law in furthering the equality for people with disabilities. And again, that would be a non-suspect class. So this is a strong state interest, although it's not a compelling state interest, to make sure that this is the way that people with disabilities are treated. So again, we go back to all these cases that we've looked at in some different topics. I'm going to let you think about these again, and I'll move forward here in about 10 seconds so that you can see the significance of each case right here. And then we go to our 8th, 9th, and 14th cases that we just talked about, and here are some of the significance of those. Okay, so hopefully you can take a look at this before Tuesday, and Mr. Sigmund will go over these things with you to ensure that you understand them, and then we're going to start to review for the big test.